during your career?
It was never deployed.
Is that what it means?
Yes.
And that would be real life. That would be when you have to use those weapons. That would mean it was an emergency situation, would it not? Well, what would it mean to you? Yeah, sorry. Thank you, Judge. What would that mean to you if you had to shoot your weapon?
That I might kill somebody.
When you three law enforcement officers, and excuse me, by the way, as far as reporting this shooting, would it be Sergeant Johnson, your boss, would be the one that would be required to do that?
Objection leading.
Well,
Rephrase it.
that. Who would be required, according to policy, to report the shooting? Would it be the shooter or the other person who was in charge there?
On that scene, it would have been Sergeant Johnson.
Because he was your supervisor, correct?
Yes.
Then I got a couple more questions. If you stopped a vehicle in Brooklyn Center and you learned that there was a bench warrant for a weapons violation, you learned that there was a temporary restraining order a female had lodged against the person that said he was in the car, that gave his identity, but he really did. Mr. Wright ever give a valid identification for himself?
No.
And the other office, now you've got no valid information, you've got a gross misdemeanor, you got a temporary restraining order, you got marijuana smelled by your partner, you got no license, no insurance. Would you let that car go if you went up to it and were attempting to handcuff the individual and the car, he jumped back in? Would you have thought you should let him go, drive down the street?
No.
On the temporary restraining order, if you learn there was a temporary restraining order, is it protocol? Is it policy to, as soon as you learn that, jump out of the passenger side, run up to the car and ask the lady what her name was? Has that ever been heard of in police practice that you know of?
No.
Thank you, ma'am. That's all I have, Judge.
Is there any recross?
Yes, Your Honor. Ms. Potter, you were asked about some statements that you made to Dr. Miller on redirect, right?
Yes.
You also told Dr. Miller that you resigned on April 12th to protect your police family, right?
Judge, I object to this improper cross-examination. I never got into that. I just got into
Your Honor, the statements to Dr.
Yes.
Miller are at issue.
I'm going to overrule the objection, and you may answer that.
You told him that, right?
Can you repeat the question?
You told Dr. Miller that you resigned on April 12th to protect your police family, right?
If it's in the report, yes. I haven't seen the report except today.
Well, if it's in the report that you also said that they're very important people to you, would that be accurate?
Yes.
You have a very close relationship with the police officers and other individuals you work with or used to work with at Brooklyn Center, right?
Some of them.
Sergeant Johnson is a good friend of yours?
Judge, I object to this and outside the scope.
The objection is sustained beyond the scope.
You also told Dr. Miller that you don't make mistakes, right? You told him that?
If it's in the report, yes.
And you told him that you don't want to hurt or injure anybody. Right?
Right?
But you mentioned to Dr. Miller your relationship with the individuals that you work with, right?
Yes.
And that was very important to you, right?
Yes.
You advocated for their interests in a lot of settings, didn't you, for the people that you worked with?
I advocate for everybody.
You had a very close relationship with them. You referred to Sergeant Johnson as a rock star, haven't you?
I don't know when I would have done that.
Nothing further, Your Honor.
Go ahead, Mr. Gray.
In all of your years there as experience in all of the patrols that you conducted, did you have to rely on your partners for assistance anytime you did a stop or an investigation of any nature?
Yes.
And that would be the family of the police department at Brooklyn Center, correct?
Yes.
And they were your second family, weren't they?
Yes.
As far as complaints, in the 26 years that you were a police officer, did you ever have one citizen complaint?
Objection, Your Honor, to the scope.
The objection is sustained beyond the scope.
I have no further questions.
Any turn to cross?
No, Your Honor.
All right. You may step down.
Thank you.
That's us.
Does the state have rebuttal?
I'm sorry, Your Honor.
Does the state have any rebuttal witnesses the defense has rested?
We do not, Your Honor. Thank you.
Okay. All right. Members of the jury, all the testimony is in. So what's going to happen is that on Monday morning, I'm going to give you the instructions of law you need to apply in rendering your verdict, and then the attorneys will have a chance to do their final arguments to you. Now, so we're starting on Monday. I've got to read the cautionary long version again so that you don't do any research. Don't let outsiders influence you. This includes family members and friends and anyone else who is not actually involved in this trial. Don't discuss the case with other jury members during the trial. Again, you'll have plenty of time to do this at the end of the trial. Once you have had all the evidence, I've sent you to the jury room with my instructions and the verdict forms. Don't talk to anyone involved in the case, of course, the defendant, the lawyers, or the witnesses. If anyone tries to discuss this case with you outside the courtroom, please report this to me. When you go home over the weekend, do not talk to your family, friends, or others about the case. You may tell them that you are a juror on a criminal case, and that is all that you should tell them. Do not report your experiences as a juror while the trial and deliberations are going on. Do not email, blog, tweet, text, or post anything to Twitter, Facebook, LinkedIn, Google, Plus, YouTube, or other social networking sites about this trial, even if I have not specifically mentioned other social media sites. Don't visit any chat rooms where this case may be discussed. Do not read or listen to news reports on newspapers, magazine, radio, television, podcasts, or other media about this case. Don't do your own investigation. Do not ask people about the case. Do not visit any of the locations mentioned in the trial. Do not use internet map applications such as MapQuest or Google Earth or similar mapping media to view the locations. Do not research anything about the case, including the issues, evidence, parties, witnesses, location, or the law through any form of written, print, electronic, or internet media, including Google, Safari, Firefox, Bing, or other similar search engine. Do not create your own demonstrations or reenactments of the events which are the subject of the case. Remember, you can't consider anything you hear or learn about this case outside this courtroom. If you don't follow these instructions, again, you may jeopardize the trial and we might have to start all over again. If you become aware that another juror may have violated any of these rules, you need to let me know that. Okay? So, members of the jury, first of all, I want to thank you for your attention during this trial. I want you to have a good weekend, and we'll reconvene on Monday at 9 o'clock. Great, please be seated. Okay, counsel. Okay. All right. All right. Okay, you should have received another draft of the jury instructions by email. I had Zach do this or Mr. Kramer do this in 14 points so us older folks can read it. Okay. So have you had a chance to review the new draft? Okay, I'd like to have a discussion about jury instructions this afternoon. Why don't we take a half an hour break? And Mr. Frank, if you could send me your suggested language on the non-deadly force. I've got one in here, a clarifying provision in it, but I'd like to see yours. So a half an hour should be enough? Okay. Okay, we'll reconvene at 2:30. Yes, you may be excused. I mean, she's coming back for jury instruction argument, right? Oh, yes. So, 2:30. All right. Counsel, we're going to... Did you want to say something, Mr. Gray?
What'd she say?
He wanted to know if he could take his mask off.
I'm behind plexiglass. Okay. All right. If you're speaking, you can take your mask off. Okay. All right. All right. Let's go through this page by page. Okay. You have our most recent draft, the one Zach sent you. Anything on page 1?
No,
No, Your Honor.
Page 2?
No, Your Honor.
no, Your Honor.
Page 3?
No, Your Honor.
Nope.
Page 4?
Yeah, I agree.
Objection. No, Your Honor.
Okay, page 5?
No, Your Honor. No, Your Honor.
Okay, now we're at page 6. Do we need a superseding cause instruction?
Absolutely. You got it in there.
It is in here. I was just wondering if it's at all applicable.
It is applicable.
Okay,
Well,
you don't,
We believe it's applicable.
What I understand the argument is going to be is that by fleeing, he's the cause. It can't, as a matter of law, be superseding of the events. So, no, a superseding cause is not
That's
just.
part of the case. You can't mandate that it's not.
okay, I'm going to keep it in, okay? Anything on 7 that you want to object to? This is,
No, Your Honor.
okay, now we're at 8. And I've changed down at the bottom, I've struck affirmative defense and just left it at defense. The jury's not going to understand what affirmative is or isn't.
Sort of sounds like
So it'll say defense hyphen authorized use of deadly force by a police officer.
you shouldn't put good defense in there. No?
The version I have, Your Honor, it does say affirmative, so are you taking that out?
We're taking out affirmative because nobody understands what that means. All right. And I think the state wanted to be heard on my change to the standard instruction on the kind and degree of force. The standard instruction did not have the hindsight language, which is in the standard instruction for non-deadly force. Or has the state withdrawn its objection?
No, Your Honor, if I can just make a record about that, we did.
Sure.
Can you hear me okay? So the state's position, Your Honor, is, first of all, that the use of non-deadly force instruction should not be given. I realize we're not at that point yet. But the hindsight language, we oppose the inclusion of that. And so if we're looking at page 9 of the proposed instructions, that last full paragraph, there is a sentence about halfway down that says the reasonableness of the particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the benefit of hindsight, taking into consideration split-second judgments, tense, uncertain, and rapidly evolving. I think we all are familiar now with that language. It's that language, Your Honor, that we feel the court should not include. Prior to that sentence, maybe I'm doing this backwards, is the sentence that says to determine whether or not the actions of the police officer are necessary, you must look at those facts known to the police officer at the precise moment she acted with force. We think that's appropriate, and that's an accurate statement of the law. All that follows is simply repeating that same concept, that, in other words, that we're limited to looking at what the officer knew at the time, and is unnecessary language, because that's already included in the instruction. That language is, we heard testimony from Professor Stoughton, and I think might have been Mr. Imes, or one of the trainers anyway, that explained that 20/20 hindsight language is about that very concept. You can't look at facts that occur afterwards. My central issue continues to be with this additional language that comes out of appellate decisions in immunity cases where the appellate court is essentially telling the lower courts, in granting or denying immunity, you can't be looking at these things that we know or learn later. And so their appellate language, I get it, they're an appellate opinion, and that's probably why they end up winning the jig. But the reason I think they're inappropriate for a district court jury instruction is because they have the force of the court's authority behind them, and they're singling out specific facts for the jurors to consider. And that's why that additional language is improper in addition to being unnecessary. It's just a way of saying, also consider these things. So in other words, when we have a jury instruction on impeachment, the court gives, hey, you could consider some of these things, but we don't go forward and say people who use drugs are not as reliable. You know what I mean? We don't use it. We don't tell them how to think about certain things. And that's what I think this language does and is improper. My feeling that what probably happened is the writers of the jigs saw that language in the opinion and included it. Our position is it's unnecessary and actually improper to add it. That is our objection to that language.
Okay. Mr. Ng.
Are we persistent in its inclusion? We had a discussion about this in chambers. This is consistent with Graham versus Connard, and we would prefer then ask you to keep this language in as it is.
Okay. Two things. First of all, the U.S. Supreme Court has specifically stated that this is an appropriate consideration in determining reasonableness. And number two, it is the standard jig for non-deadly force. And I'm just using the same standard in the deadly force instruction. So that hindsight language is already part of the standard jig for non-deadly force, but not for deadly force. There's no reason why it shouldn't be in the deadly force instruction. Okay. State's objection noted. And then number 10, at the top, the title should be use of non-deadly force, and strike authorized and strike defined. Then I like the state's suggestion on explaining this taser use. Did you get a copy of the state's?
Well,
Okay.
we did get a copy of it.
All right. They're saying in this case you have heard testimony about whether, first of all, is the state objecting to any instruction on non-deadly force?
We are, Your Honors, as we argued before, the only use of force at issue in the case is the firing of the gun, which clearly is deadly force. And so we continue to take the position that the jury should not receive an instruction on the use of non-deadly force.
Okay, and I've overruled that objection because the state's expert stated that the use of the taser was unreasonable and inappropriate. So the state's expert really made it an issue. So, Mr. Ng?
Yes. Well, we read the state's proposal. We would object to the first sentence of the state's proposal and the last sentence, and then leave the balance of the instruction in.
Your Honor, I'm not going to argue that authorized use of non-deadly force is a defense at all. I might argue about it, talking about Professor Stoughton, Mr. Professor Stoughton, but I'm not gonna claim that. It's unnecessary. I mean, if I do, are you gonna instruct before or after the arguments?
Before.
Oh, okay. Well, then I can do it.
Okay, and, I like the state's language. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. I think that's accurate. And I would go down to the statutes of Minnesota provide that a police officer is authorized to use reasonable force in the line of duty, period.
Now, we would like you to say in executing a valid arrest warrant.
Well, you are instructed that executing a lawful arrest warrant is a duty imposed on officers by law. That's so subparts 1 through 4 are just duplicative and confusing. So there be a period after line of duty, and we would strike 1, 2, 3, and 4 and go straight to you're instructed that executing a lawful arrest warrant is a duty imposed on officers by law. And then the standard instruction on reasonable force. And I also like the state's suggestion on the explanation. Whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case.
It's not an absolute defense, I think you should put, because the evidence is entered into this case, and this professor says that that was a violation too. So I just think that if you're going to comment on it, but is whether the defendant's apparent decision to use a taser was reasonable or appropriate is something you may not consider in order. Well, leave it alone. I'll argue. No problem, Judge.
Okay. Are you withdrawing your comments?
Pardon.
Are we okay with the state's proposal then?
Well, I'm in a state of confusion always.
What? The actual language, whether the defendant's apparent decision to use a taser was reasonable or appropriate, is not a defense to the charges in this case.
But I can't argue, Judge, that her decision was appropriate as far as she was concerned.
Yeah.
She testified to that.
Yeah. You can argue that she could use a taser under the circumstances.
I do have a question.
But you can't say that she's not guilty of either charge because the use of the taser was appropriate.
Yeah, but it shows circumstantial evidence that she was in good faith, that she wasn't intentionally doing anything devious.
Well, okay, you can't argue that it's a defense. You can't say she's...
I argue it as a defense.
Yeah.
But I am going to argue that Mr. Stoughton said that in his incredible opinion, he said that even what she did with the taser was unreasonable and appropriate. Read the instruction about Mr. Stoughton's opinion, and I'll point to it. That's all.
Okay.
So are you doing in toto the state's proposal here? Are you substituting it all in? Or you just help me with what you're doing exactly at the top? I may have missed it, and I'm sorry to indulge.
Okay. I am adopting the state's proposed language, the introductory language. So it'll say use of non-deadly force. That's the title. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. And then the last sentence would be whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case.
You're going to cross off the state's 1 through 4
Right, 1 through 4. 1 through 4 is effectuating a lawful arrest, executing legal process, enforcing an order of the court, or executing any other duty imposed upon the officer by law. I mean, right under that, it says you are instructed that executing a lawful arrest warrant is a duty imposed on officers by law. Do you want additional language in there?
Well, we would like executing legal process, enforcing order of the court. I mean, what we asked for was the statute, 609.06, and the language of the statute should be
Okay, we can put the...
included in our...
Okay, we'll put it... Oh, with all due respect. Okay, we'll put that back in.
That was probably
Okay, now, anything on 11?
Can I just make a record about this?
Yes.
So I indicated before, I think, so it may not need repetition, but I will, just our continuing objection to have this instruction in at all. And I want to point out that we also, of course, have the objection to the hindsight language in the definition paragraph here, consistent with the court's other definition of it in the deadly force. And then, Your Honor, I should point out, that paragraph is different as well, just so we're all clear about this, in the first line, where in the deadly force instruction, it starts out saying, as to each count and defense. Right? So do you see what I mean? In the deadly force instruction, that last paragraph starts out as to each count or defense. I did not include that in the non-deadly force definition so that there wouldn't be any confusion when we go on and tell them this isn't a defense, right? I just want that.
Yeah, Joseph, I'm sorry.
So that, and then, Your Honor, if we're going to if we're going to reinsert paragraphs 1 through 4, I would ask the court to take out arrest in the next sentence. You are instructed that executing a lawful arrest warrant. All the testimony in this case has been that it was a bench warrant or a warrant. And so to call it an arrest warrant, I think it misstates it.
Judge, I just noticed, and I've had a few of these, what we missed here, and I walked by, at the page 7 on count 1 and count 2 both, at the end of that, when if you find that each of these elements been proven beyond reasonable doubt, the defendant is guilty. If you find any element that has not been proven beyond reasonable doubt, the defendant is not guilty. In addition, if you find that the state failed to prove that reasonable force, give me the language, Paul.
Well, once self-defense is raised, they have to prove it beyond prove she didn't act in self-defense beyond reasonable doubt.
Yes. So that should be in here, because otherwise they say, well, the judge says if they prove these elements, he's guilty. But you got to warn them. Look at the self-defense or reasonable use of force instruction. And if the jury finds that it was reasonable use of force, they're not guilty. So you got to put in there that
once you raise the defense, they have to disprove it beyond reasonable doubt.
Right. It is on page 10 at the top of the page.
You know, but my argument is with the last paragraph of count 1 and count 2, where you tell them if the elements are proven beyond reasonable doubt, the defendant is guilty, unless the state whatever. You have to put that in there that the state has the burden of proof to prove that reasonable force. There's the language. Help me out, Paul.
You are I'm sorry if I may.
It's in here.
At the bottom of page 8 is when the court's instructions start talking about defenses, it plainly says Minnesota law provides that no crime is committed and the police officer's actions are justified. And then, of course, as the court pointed out, at the end of the instruction, it says they're not guilty of a crime.
So it's in there. You're covered. Okay. All right, let's go back. Let's go back to page 9, the last full paragraph. I'm wondering if the language that says as to each count or defense is confusing.
We don't think so.
Okay, leave that the way it is. Is what the defense says, right?
Yeah, we want to.
Okay. All right. I shouldn't have brought it up because everybody agrees, right? All right, where were we? Are we on page 11?
Well, I think we're all done with the non-deadly force changes. I did ask, Your Honor, to have the court remove arrest between lawful and warrant in the non-deadly force instruction.
You know what? I'm going to leave everything in there. Like, you know, I just tried to make this a little bit easier for the jury, but if the defense wants it in there, I'm going to leave it in there. Okay, are we on 11? Anything on 11?
No, Your Honor.
No.
Anything on 12? The implicit bias instruction is incorporated under duties of jurors. So 12 or 13?
Nothing from the state, Your Honor.
Okay. And did you have a chance to take a look at the verdict forms? Oh, okay. No objection to the verdict forms either, right?
They haven't changed at all since the last one.
No. Okay. Here's what I'd like to do. First of all, yes. Oh, I like it when you raise your hand. Okay. He raised his hand first.
Before we transition out of the jury instructions, the defense did request an instruction on policy, and we would like a ruling one way or another. The instruction that I requested via email, which I'd like to read into the record and get a ruling from you. Brooklyn Center police policies are not criminal statutes, period. An alleged violation of a policy is not a crime, period. And we requested that on December 14th, and the court deferred ruling. We do persist in requesting that, and if we would like a ruling one way or another from you at your leisure, but I do want to persist in that.
Okay, I forgot about that. Does the state object? I mean, it's true.
Yeah, it's true but unnecessary. We're defining the crimes for them, and very specifically telling them to find them guilty, you have to find these elements. And it's just not necessary, potentially confusing, to give them a specific instruction about policy.
Okay, I'm going to include it because it's true, and it's an accurate statement. Okay.
I'm sorry. We had requested some language be added to the instruction because it's not incomplete. I mean, it's not complete. And I'm trying to remember the exact, because I don't have it in front of me, but but it can be considered in determining, whether the defendant is guilty, because that's also true. Right? It is evidence in the case. And so
I'm not going to talk about that. You can't consider that in determining whether she's guilty or not guilty. Plus, I don't know what we're arguing about. The Brooklyn Center policies are consistent with the law. So I'm not going to add that additional language, but where would you like that put in the jury? Where do you think it fits?
right after page 5, after demonstrative evidence, all charges are consistent. Be fine.
Okay, we'll put it on page 5. Right after demonstrative evidence. All right.
Judge, what will the title be?
Oh, yeah. What's the title?
Pauline,
Evaluation of policies.
Consideration of
Yeah,
policies?
consideration of policies. Would be fine.
Okay. Consideration of policies. Okay. I'll make the changes and recirculate another copy. We'll do it in 14 inch, okay? So, and if you notice anything at all, any typos or anything, let me know by no later than 4 o'clock, okay? And let's see. Oh, would the defense take the time, please, to look at the thumb drive on the computer that the state has? That because there's a computer, a laptop that's going to go to the jury room, right? And then there's that thumb drive with all the exhibits on it. So I want the defense to stay and look at all the exhibits so that you can confirm that all the exhibits that were entered are on the thumb drive, and check out the computer, the laptop, to make sure that it's clean of any other material. The laptop that goes back with the jurors will not have internet capability, okay? And then tomorrow morning, I just want to put on the record that you've had enough time to look at that, look at the thumb drive exhibits to make sure that's appropriate, and that you've also had a chance to take a look at the laptop and make sure that it's appropriate to go back to the jury room. So we'll make a record of that tomorrow. And oh, that's okay. Oh, yeah. We'll do it Monday. Okay. I misspoke. Okay. Yeah.
I had just circulated an email to everybody about the 2 defense exhibits. We need to get electronic copies of those to put on the... You're on that already?
I sent you our 2 electronic
Did you?
exhibits. Yep.
Okay. And then we try to keep track of all exhibits that were received, and I, of course, would like to think we are flawless at that, but I would rather seek some corroboration. So if the court has an exhibit list, I'd like to kind of cross-reference ours with theirs, with yours, and then once we do that, we can dump all that onto the electronic stuff we need to.
Okay. Yeah, Mr. Kramer's going to help you with that. Okay, what else? I think that's it. All right, counsel, I just want to tell you that I've really enjoyed having you. It was a really well-tried case on both sides.
I kept making those long objections, okay?
You can't help yourself, can you, Mr. Gray? All right. Okay. Have a relaxing weekend if you can.